Welcome back to the 8-Figure Attorney Podcast. I'm so excited for our next guest, Bethany Schneider. Bethany, welcome.
Thanks for having me.
Bethany is the founder and owner of Schneider Injury Law right here in Atlanta, Georgia, right?
Yep.
Bethany, we had a chance to talk before you came on, and there's so much for us to talk about, but where I want to start is 2018. 2018, you took a leap of faith and opened your firm after working for 8 years at one of the top law firms, not just insurance defense firms, but really top law firms, not only here in Atlanta, nationally, but really throughout the world, King & Spalding.
Yeah.
So like, what was that like to take that leap of faith? I mean, you had I'm sure a really great job, a prestigious job with I'm sure a very big salary. Tell me, why did you make that move, and what was that like?
Yes, I was very fortunate to have worked at King & Spalding for, a long time, getting trained by some of the best lawyers in the country, best trial lawyers that I've ever met. And I had the opportunity doing tobacco defense to actually try a lot of cases. I went to 24 trials in Florida during my time. I was in the courtroom for 11 of them. And I had so much great training and experience. And I would watch myself a lot on CVN, Courtroom View Network, which is a video, they film trials and everything. And I just got to the point where I was watching myself, and I'd always wanted to be a trial lawyer. I never had pictured myself doing anything else. And so I just felt like in watching myself, speak to juries, that I was not able to really utilize my strengths, which I think are my passion, and my, emotional connection with the jury. And so as a defense lawyer, you're really trying to kind of, lower the temperature in the courtroom and trying to take all the emotion out. And so I felt like I was kind of being stifled in what were my strengths. And so I, felt like at that point I was 33, single, no kids, and thought, I think that I've had enough training to really do this and try this on my own. And I felt really called to kind of represent and bring this big firm, corporate level quality representation to injured individuals. And a partner on my team actually left and switched sides to go to be a plaintiff's attorney. And that got me really thinking. And so I kind of did my homework and talked to a bunch of plaintiff's attorneys and made sure that it was going to be the right fit for me. But in the end, it ended up being just a leap of faith and kind of faith in myself that I, could kind of take on this new challenge to open my own firm and switch sides and basically have to learn everything all over again.
I understand, because I actually worked as a defense attorney before switching sides, and so I can totally relate to that. I'm curious, though, like you say that you always knew you wanted to be a trial lawyer. Why is that?
Growing up, I was in the performance arts. I was in, acting and singing and things. And I just always was somebody that liked performing in front of people. And as my mom told me when I was in high school, I like to argue and I like to get my point across. And I always felt like this core commitment to justice and, the right way for things to be. And so I felt like being a trial lawyer kind of had all of those things wrapped up, the performance, but also the persuasiveness and the gamesmanship that kind of go into it too, and the competitive nature of it. So it just I could never imagine being anything other than a trial lawyer. That's
amazing. And I'm curious now, you mentioned that you grew up acting and performance arts. Like, how is that a benefit to you? And more importantly, how is that a benefit to your clients?
Well, sometimes I have to try to bring it down a little bit because I can be a little overly dramatic. Okay. But I think that it has made me, much more comfortable in the courtroom. Now, I think that, coming up as a trial lawyer, I had to learn that I wasn't playing the part of a trial lawyer. Like, I had to be a trial lawyer, and that had to be, my genuine self, that I could come out and I could bring some of the drama at different points in time.
I see.
During maybe cross-examination or something, or closing. But that I think you have to combine that with also trying to be your genuine self. But I mean, my genuine self is pretty bubbly and maybe dramatic, as well. So I guess it all goes together.
Sure. Do you find that, I'm curious to know, you've been in front of many juries, and I'm curious to know if your ability, your comfort level, performing and being emotional and being passionate helps you connect with juries.
I think so. And it has been, a learning process, and getting, just like everybody, having to get more comfortable in basically standing up and having that connection with the juries. But I think that over time, I have learned how, which I think is one of the most important tools to be persuasive, but how to vary, your emotion based on what you're trying to convey at that point in time. Mm-hmm. And so all that goes into it with like volume and tone and, pauses and all of that. But I do feel like, because I feel like I'm very self-aware of kind of how I'm being portrayed. And so I think that, and it's taken a long time to get that way, taken a lot of time standing up in front of a jury and watching myself on video and everything. But, I tried a case a couple of weeks ago, and I felt the most, even after the long break of COVID, I felt the most comfortable and able to really be genuine standing up in front of a jury. But I think it just takes a lot of practice too.
Sure.
And watching yourself, like that, we have the benefit of CVN, or if you can just, even tape yourself, like practicing. I mean, watching yourself on video is really important, I think, key to learning and getting better. And some people hate doing that.
Yeah. No, I
it can
understand.
be uncomfortable.
So just to go back to your defense work, right? I mean, I think that is a unique value proposition that you and I both can offer to our clients, because not every trial lawyer, not every lawyer that represents, injured people, whether in a workers' compensation case or a negligence case, a products liability case, not every lawyer has that background as a defense attorney. So can you talk a little bit about that, the work you were doing at King & Spalding? You mentioned defending big tobacco, and how that trial work you did as a defense attorney has really helped you now as a trial lawyer.
Yes, I was defending R.J. Reynolds Tobacco Company. And so, I think it's universally understood that tobacco companies are not very well liked, especially in a courtroom. And so having to go into, and starting my career, having to go into a trial in a courtroom kind of with, representing a really, disliked client, really instilled in me that fearlessness that I think helps my clients now, because it's kind of the opposite of, or kind of the same thing as, personal injury plaintiffs. So, when we would go into a case as a tobacco company defendant, all the odds were stacked against us. We were never going to get the benefit of the doubt in things, because people already came in with a lot of, preconceptions. Same thing as a personal injury plaintiff, I think, in these other types of cases that we go into, car wrecks, med mal cases, those kinds of things where people do come in, I think, with some preconceived notions about personal injury plaintiffs. Sure. And so it's helped prepare me for knowing certain things and having trial strategies when you're the one that's kind of not getting the benefit of the doubt. I know, and I've seen a lot of personal injury plaintiffs lawyers who kind of go into trials and think they're going to get the benefit of the doubt for something. They're going to, maybe they go aggressively after a witness because they know that they've been lying, in a deposition or something, where I've had to say, you're not going to get the benefit of the doubt as the personal injury, like plaintiff's lawyer, Right. And so one of the biggest lessons I've learned, and I do, have a whole thing on my website about how insider knowledge, really helps. And I can use that as a strength for my clients, but preempting things. So having the ability to really look at your case and recognize the weaknesses of that, and having the ability to not be scared to kind of put that at the forefront and bring that out yourself. I think a lot of PI plaintiffs lawyers do kind of shy away from things and just hope and cross their fingers. Oh, hopefully this isn't going to come up. But what my defense, experience really taught me is you got to try to preempt, you got to front load everything, because all you really have as somebody coming in, either as a tobacco company defendant or a, plaintiff, personal injury plaintiff, is your credibility.
Sure.
And so if you lose that, then you've lost the jury. And so that's one of the biggest lessons I've learned, is all about preempting the other side and bringing out your weaknesses. But what I call it embracing and weaponizing the defense's favorite facts.
I love that. So I'm curious, when you go into a trial, do you prepare your clients now and explain to them that there are weaknesses and how you're going to help sort of get past them? Because I know sometimes as a lawyer, it's hard. Your clients don't want to accept that there are some challenges. They're certain they're injured and it's the other person's fault, or the company's fault, and they are sometimes they're not willing to accept that it's not a slam dunk. So I'm curious to know. I understand how you embrace the weakness and weaponize it against the defense, but I'm curious how you prepare your client for that.
Well, in the two, 7-figure verdicts that I've gotten over the last few years, I had some really tough facts. One was the TBI, case that I had where we had a 3-year, 3-month, 6-day gap in where the injury occurred and the diagnosis. And then the other one was where we had a car wreck case that was a neck surgery case where we found out 2 weeks before trial there was a 2007 undisclosed neck injury. So in both of those cases, you're right. We did have to talk to the clients and say, these are really hard facts in these cases, but we're going to, craft our cases around this. So for instance, in the TBI case, we really built both with our own client's testimony, but also the friends and family testimony to close that gap, to show all of the things that were actually occurring during that timeline and why just because there was no diagnosis, it didn't mean that he wasn't hurting or experiencing that in the middle of that. The undisclosed neck surgery, the undisclosed neck injury case, we had to talk to our client a lot about okay, we told you better tell us everything beforehand. This is the most important thing. She's like, I really forgot. It wasn't that big of a deal. But we told her and prepared her to say, this is what you lose cases on. If we don't come out and really show why you didn't tell the other side about this and why this doesn't matter, you could lose on this, and really kind of and basically saying it's your fault.
Yeah, no, I get it.
But saying, we're going to come out. And I think the first thing I asked her when she got on the stand was, hey, the elephant in the room, what about this 2007, neck injury? Why did you not disclose that? And so, you just got to, like you said, kind of prepare your client for it and prepare them for the reality that these are things that they could lose their case on. Yeah. It always ends up that there are some bad facts, I guess, because they're not settled. If they were no bad facts, they would have gotten settled. Sure. But
yeah, but it's certainly easier if we can control, as the trial lawyer, to control the narrative and tell the story and provide some context. It's a lot easier than if the other side is the one telling the story. Yeah. So. And
I do think also in trial, when your client sees the opening or sees the jury selection and sees you kind of attacking those weaknesses up front, then by the time they testify, they're prepared and they want to have the opportunity to explain why these aren't weaknesses in their case.
Right. So I want to turn to your experience as a brain injury specialist. I see tons on social media. You're a certified brain injury specialist, right?
Yes.
Okay. So tell me about that. First, when did you become certified and why is that significant? Why did you do that?
Well, in 2019, I had a TBI case with Betty Davis, another, personal injury lawyer in town. And we really went to school on traumatic brain injuries in order to prepare for that. I think at that point, I feel like TBIs are a big thing now that's talked about a lot. Back then in 2018 and early 2019, when we were preparing for trial, it just wasn't as well known. Okay. And so we took a lot of time to learn from the neurologist who was testifying in the case, the neuroradiologist, and we even went to TBI Med Legal, a conference out in California to learn about it. And so I got, really interested in it because I felt like, kind of like the tobacco cases, there was a very challenging area of law where you have this invisible injury. And that one of the things I liked most about tobacco, trying those cases, was taking very complicated medical issues and distilling them down and helping to explain them to lay people. I found that to be, very mentally stimulating and challenging. And I felt like that in the brain injury area too, is that, here's this very complicated medical area, and to try to explain that to lay people so that they understand kind of the breadth and scope of that injury. So we got a $5.5 million verdict in that case.
Congrats.
And from that, thanks. And so from that, I got a lot of calls about TBIs, both for people wanting to associate me on cases or just for people wanting advice on their own cases. So I got a lot of TBI cases and I just started working on them more and more. And so then I was offered the opportunity to go through the course through the Brain Injury Association of America, where you would go, it's like a 1-day, 8-hour course, and then you take a test and to get certified. And
so actually you had not been in 2019 when you secured the $5.5 million settlement. You actually had not been certified at that point.
Right. I was only certified as of, I think, April of this year.
Got it. Now, not every trial lawyer is certified brain injury specialist, right?
Right.
And I mean, do you think that certification and now, of course, your experience with TBIs sets you apart from other lawyers that might be phenomenal lawyers, but may not have the experience you have with traumatic brain injury?
I think so. I mean, I obviously think that any lawyer, like good trial lawyer, can probably learn, this area with enough, schooling and educating themselves. But I think that because there are things now in trying these cases and working up these cases over and over again, I think there's a lot of things that I know about defenses that are going to be used, that I know exactly how to combat those and how to nullify some of the points that the defenses are going to make just through my own knowledge of, brain injuries and my own medical knowledge.
What are some either common things you're looking for in a traumatic brain injury, or some common defenses that you see, and how do you overcome them? Or, what are you looking for when you're building a traumatic brain injury case? Well,
the biggest thing is that 90 to 95% of traumatic brain injuries resolve over the course of a year. Okay. And so, if people are having cases that have just happened where they have a patient or a client that has had a concussion and they're trying to, do a bunch to work up a brain injury, I usually tell people don't do that. Because, most will resolve over the course of a year. And so that's one of the biggest things that I think I've learned and tried to help other people learn, is that while you do need to kind of be monitoring the situation early on over that first year, that hopefully, doctors will tell them and the literature tells them, that they'll get better. So that's one of the biggest things that the defense uses against us in TBI cases, even down the road, 2 years if they're still experiencing symptoms. Most of the defense experts that they'll get will say there's no such thing as a permanent traumatic brain injury, because that's what the literature used to say.
I see.
However, the newest literature that's coming out is showing that there's more and more permanent traumatic brain injuries, and that this is a very underreported phenomenon, because it's very hard to recognize for the client themselves that they have a traumatic brain injury, because it's this constellation of symptoms that they wouldn't necessarily put together themselves. And that's part of the reason we had the 3-year, 3-month, 6-day gap in my first case, because he had headaches. And so we thought it was a headaches case. But then when we started talking to family members, we found out that he was having memory problems, irritability, personality changes, outbursts, fatigue. I mean, lack of focus, and all of those things. I don't think, number one, emergency rooms don't tell you, okay, you could have this, this thing happen over the course of time, and you could experience all these symptoms. And a lot of doctors don't recognize it either because they don't ask the right questions.
I see.
So one of the biggest things that I do in my cases, and I send to other people who think that they might have, people with traumatic brain injury cases, is this questionnaire that you fill out that puts all the possible symptoms in front of them. And then all of a sudden you're seeing somebody that maybe you thought it was a headaches case, and you're like, no, wow, there's all these cognitive issues as well, personality changes, anxiety, depression, and all of this can be explained by one thing versus what other people may have missed and not really recognized that this was.
So where do we get that checklist? I mean, I'm sitting here listening, thinking, or hoping I didn't miss any cases along the way.
I know. I'll send it to you. It's called the Philadelphia Head Injury Questionnaire.
I got you. So it's not the Schneider injury law.
No, I didn't make it up. No, I got sent it one time too by another attorney.
I got you. So we'll have to check that out and share that with all the lawyers in my office. Okay, so I guess you've had a chance to talk about the $5.5 million case. Is there anything else about that case that was unique? I mean, this is the 8-Figure Attorney podcast. You've done over $15 million, probably over $20 million by now in just a few years of practice. But is that your biggest result so far?
Yes, yeah, because in addition to that, we had $1 million settlement like on the eve of trial, and then we had $1 million added to attorney's fees. So. Wow. Yeah, so we already got paid that first $1 million, which always helps, in like the, long run afterwards.
Sure.
But yeah, it's my biggest result by far.
Is there anything else that's unique about that case or about how you were able to get it? I think initially they didn't make that kind of offer.
No.
Take me through just kind of, because a lot of people are listening. There's a lot of lawyers that, are wondering, how do you build these cases up? And there's a lot of folks that don't understand how trial lawyers work and help build cases. So, I mean, take me through just generally where, what was their initial offer, if any, and then how did you ultimately get the result you got?
I don't even know if they made any kind of initial offer. So I got brought in by Betty Davis into the litigation. So it occurred in 2015, and I got brought in 2018. And so before I was involved, she had made a $75,000 offer of settlement.
Wow.
To the defendant, the general contractor defendant. So what happened was it was a hotel where they were doing construction on a 4th-story pool deck, and an 8-foot metal electrical pipe fell off the 4th story because they didn't have any safety precautions whatsoever. No netting, no signs, no nothing. And hit our client, a taxi cab driver who was standing outside on the sidewalk, in the head. And, he had a broken nose that he had to have surgery for. And then he was having some headaches. But he was a Haitian man. And so he was kind of stubborn. And that's one of the themes that we built up in trial. He wasn't a complainer or anything. So he had the nose surgery. And then, he reported some headaches, but then just kind of like went along. And so then when he was deposed, he reported the headaches and some vision issues, but so Betty, when I got the case, was working it up like a headaches case. And one of the kind of, I guess, lucky things about getting, not really getting an offer in the case and being able to try it was because this happens a lot, I think, in some of our cases, is the defense were pointing fingers at each other. So neither one wanted to pay any money because they said, oh, it's the other, person, the other company's fault. And so they were so worried about pointing fingers at each other that they didn't really work up the case at all. Wow. And so they hadn't named any experts or anything. And so when I got involved in the case, Betty was saying, hey, he is reporting these things. I've heard about this this test called a DTI, diffusion tensor imaging. It's a highly specialized MRI that could show maybe a traumatic brain injury. Do you think we should send him for that? And we'd have to say that we basically sent him a couple of years after the initial injury. How do you think that would be portrayed in trial? And I was like, well, we got to get proof of our injury, so let's do it. So we sent him for that, and it actually turned out that it was showed like the most significant changes that the neuroradiologist, Dr. Owens, had ever seen. And so from that, then we sent him to a neurologist to, get treatment because he'd not had treatment for all of this time. And so I think the defense was just completely blindsided by the fact that this ended up being this permanent traumatic brain injury, despite the fact that we had, told them all along the way. And we'd offered up until trial when they knew what we had. We even deposed, our neurologist ahead of time and everything.
Yeah.
And so we were offering to settle, for the policy limits, up until trial. And one defendant, smartly took that and the other didn't. So then I think they thought the gap was going to win the day. But one of the proudest things about that trial is that, and this was a reason that a lot of other people didn't take the case. Betty had offered it to kind of shopped it around to some other people. And they were like, oh, this is not a big case, And so I was kind of the naive, person coming over. And I'm like, oh, cool. Sounds great. And so we kind of hit the 3-year, 3-month, 6-day gap so hard in building our case around it, bridging that gap, that in the punitive verdict, they came back with $500,336. We were like, what's that 336? And the jury talked to us afterward and said, you see that 336? And we're like, yeah, what's that from? The 3-year, 3-month, 6-day gap.
That's amazing. So that was almost like, that was maybe a theme or something you guys talked about throughout the case. Mm-hmm. Wow.